Let's look at them one by one. So the first one is trademark infringement action. As you may be knowing, most of the times event organizers register the event related logos and marks at the national trademark registries in different classes of goods or services to cover a wide range of goods and services. For example, before FIFA World Cup 2018, FIFA will be attempting to register FIFA World Cup 2018, 2018 games, etc. in different national registries. But whether the registration becomes successful or not is something that will be depending on national laws and the practices followed by different national trademark registries. A trademark will be infringed when a person other than a registered proprietor or a permitted user uses a mark which is identical with or deceptively similar to that of a registered trademark in the course of trade. When we analyze this condition in detail, we see that the mark used should be either identical or deceptively similar to the registered mark. The goods or services in respect of which it is used must be specifically covered by the registration. The use must be in the course of trade in the areas covered by registration. The use must be in such a manner as to reflect its use as a trademark. And finally, the defendant should not have been a permitted user. And a person is considered to have used a registered trademark when she or he affixes the mark to goods or packaging thereof, offers the goods for sale, market or stock or supply services under the registered mark, imports or exports the goods under the mark, or uses the registered trademark on business papers or in advertising. In situations wherein an identical mark is used in relation to similar goods or services, or where a similar mark is used in relation to identical or similar goods or services, there will be infringement if such use is likely to cause confusion among the public or is likely to create an association with the registered mark. In the case of identical marks on identical goods or services, there is no need to prove confusion as there will be a presumption that it is likely to cause confusion to the public. Two important cases which I don't want to discuss in detail here because it will be discussed in your other modules, which can be very useful in the infringement analysis are the piano twist application case and the British sugar case. So please do refer to them also. The trademark infringement action can be used against ambush marketing under certain situations. For example, if ICC has been successful in registering Cricket World Cup as a trademark in respect of certain goods and services in a country, and if someone uses that mark on class of products or services for which ICC has obtained registration, ICC can then approach the court on grounds of trademark infringement. But in such a hypothetical situation, the success of infringement action depends on 1. The registration of the mark, 2. The use should be use of identical or similar marks by the defendant, and the use in respect of the same class of goods and services for which ICC had obtained registration. One of the interesting cases which shows the usefulness of trademark infringement action is Boston Athletic Association versus Mark Sullivan. So in this case, the organizers of Boston Marathon, an annual event, approached the court to enjoin the defendant from manufacture and sale of t-shirts and other wearing apparel with the marks BA Marathon, Boston Marathon and its unicorn logo. The main argument of the defendant was that Boston Marathon had become a generic term. However, the court ruled in favor of the plaintiff and enjoined the defendant from infringing the service marks of the plaintiff. Some of the marks may also get additional protection as well-known marks. The advantage of getting protection as a well-known mark is that the protection will extend to dissimilar goods or services. So for example, if ICC Cricket World Cup can be proved as a mark with reputation in India, ICC will be able to prevent the use of its mark on any goods or services irrespective of the classes in which ICC already has registration. But now we should also know what are the limitations of trademark infringement action. The most important limitation is that ambush marketers often do not use or display registered marks of the event. They instead create a false association with the marks through their ingenious methods. The best example to illustrate here is a advertisement strategy used by American Express during the Barcelona Olympics. So the slogan which they used is, "And remember, to visit Spain, you don't need a visa." As you can clearly see here, they didn't use any of the marks associated with the event or their corporate rival. But at the same time, they ambushed the event organizer and the sponsor in a clear way. It is also important to note here that trademark infringement action will be of little or no help in most of the common ambush marketing practices like buying commercial time during the telecast of events, making independent contracts with athletes and teams, throwing parties and other events in the host cities before, during or after the event, buying advertisement spaces in and around the event place, and even making people wear apparels with the ambusher's mark and carry products, signs or accessories bearing the ambusher's mark to the event place. Finally, it is also important to note that proving the likelihood of confusion, which is a necessary ingredient in most infringement actions, is difficult in most instances of ambush market. Another major issue in many countries like India is that the title of events like World Cup may be considered by the trademark registry or the courts as generic words and hence not capable of registration. For example, in the famous case of ICC Development International Limited versus RV Enterprises and another, the court was clearly mentioning that World Cup is a dictionary word having the meaning a tournament or event where several nations participate. Court considered it as a generic term which is not capable of conferring any exclusive rights for the event organizers. Now let's have a look at the effectiveness of copyright infringement action. As you might be knowing, copyright protection also exists in different areas relating to an event. For example, the logo created by the organizers of the event can be protected as an artistic work. Or alternatively, various literatures relating to the event, like the official document that provides details about time, venue, etc., also attains copyright protection provided it satisfies the minimum requirements for obtaining copyright. An important feature of copyright is that there are no requirements to go for registration of the work to achieve protection. Copyright infringement happens when a person other than the copyright owner reproduces or imitates any of those copyrighted materials relating to the event. Some of the important factors to be considered while determining a question of infringement are whether the plaintiff is the owner of the work, whether the defendant has carried out any activities falling within the domain of the copyright owner's rights associated with copyright law, whether the defendant's work was derived from the copyrighted work, and whether the defendant has copied whole or substantial portion of the copyrighted work. In the context of ambush marketing, copyright infringement action can be helpful in cases where the ambush marketers copies the logos associated with an event. Because, as I mentioned earlier, logos can be protected as artistic works and reproduction of such logos in any medium will result in its infringement. One of the important cases which I would like to mention in this context is ICC Development International Limited versus Evergreen Service Station and another. In this case, the defendant used the logo of the plaintiff during its promotion campaign. Delhi High Court held that the logo denoting black and white stripes of zebra was an artistic work within the meaning of copyright law and hence subject to copyright protection. As a result, the defendant was restrained from using the logo of the plaintiff in its advertisements. But it needs to be noted here that even though the court upheld the argument of copyright infringement, the larger question of violation of the rights of the plaintiff through ambush marketing was rejected by the court in this case. The only restraint imposed by the court was the use of the logo of the plaintiff. We must also know the limitations of copyright infringement action in the context of ambush marketing, and most of the reasons that fails a trademark infringement action are likely to fail the copyright infringement actions also. For example, most of the ambush marketers do not use or display logos or other copyrighted materials relating to the event directly, and they normally create a false association with the marks through their ingenious methods. And it is very difficult to bring them within the parameters of a copyright infringement action. And the same American Express advertisement example I mentioned in the context of trademark law will be equally applicable here also. And if the matter is going to the court as a copyright infringement action, it is very unlikely that the court will be saying there is a copyright infringement in that advertisement slot.